It all started on April the 29th, 1998, when the Nigerian military government, led by General Sani Abacha, awarded Oil Prospecting License 245, also known as OPL 245, to an unknown and newly registered company. The name of the company? Malabu Oil and Gas Limited. Then 3 years after, on July the 2nd, 2001, President Olusegun Obasanjo revoked the license. And that marks the beginning of the series of controversies and tussles that gave birth to the OPL 245 saga, tagged by sections of the media as a Malabu scandal. There are 1,001 questions over the saga. What actually went down? Why did President Obasanjo revoke OPL 245 in 2001? Why did President Goodluck Jonathan return the oil block to Malabu in 2010? What was the interest of the Abacha family in OPL 245? What was the interest of President Muhammadu Buhari, whose government filed criminal charges against the principal actors? How did Mohammed Bello Adoke become the central figure in the court cases? And most importantly, why did Nigeria lose all the major OPL 245 court cases in Italy, the UK, and Nigeria? Questions, questions, questions. Now, what you're about to hear is the inside story of the OPL 245 affair the way you have never heard it before. The story has been told in bits and pieces, but now we tell you in authoritative detail. My name is Kayode Okikiolu, gentleman of the press, and this is a Malabu Gate story. So let's start from the very beginning, shall we? You see, Nigeria discovered oil in commercial quantities in 1956 when Shell BP, as it was then known, hit the black gold in Oloibiri in the Niger Delta. Well, Oloibiri is located in present-day Bayelsa State. And in 1958, Shell BP began production and export. Now, there was no huge revenue for Nigeria until 1973, when the Arab-Israeli War led to a spike in oil prices. So oil-producing countries experienced their very first major oil boom, and the world has never remained the same again. Now, that was the beginning of Nigeria's stupendous oil wealth. However, despite the strategic nature of oil to the economy and politics of Nigeria, well, exploration was being done by only foreign companies. Well, the National Oil Company, which is now known as the Nigerian National Petroleum Company Limited, only exists to manage Nigeria's interest in the production ventures. So, between 1985 and 1993, General Ibrahim Babangida, who was a military president at that time, then decided to get indigenous companies fully involved in the oil industry. He introduced the Indigenous Exploration Program in 1993 to sort of incentivize Nigerian companies to participate in oil exploration and production. Now, one of the incentives was to lower the entry barrier through a concessionary signature bonus of $20 million. So local companies were also granted a special dispensation to engage oil majors' technical partners. So early beneficiaries included Oriental Energy Resources Limited, owned by Alhaji Muhammad Ndimi, Consolidated Oil Limited, owned by Dr. Mike Adinuga, and Famfa Oil Limited, owned by Mrs. Folorisho Alakija. Well, the government of General Sani Abacha, who became head of state in November 1993, awarded several prospecting licenses in 1998. OPL 246 was awarded to the South Atlantic Petroleum Sapetro in February 1998. Well, Sapetro, by the way, is owned by General T.Y. Danjuma, former Chief of Army Staff and an associate of General Sani Abacha. OPL 245, on the other hand, was awarded to a company known as Malabu Oil and Gas Limited. But then, General Abacha died suddenly on June the 8th, 1998. Before we delve into the intriguing story of Block 245, here are some quick facts.
The oil block is 150 kilometers off the coast of the Niger Delta and 1,000 meters below sea level. By 2006, about 1 billion barrels of oil equivalent had been discovered in Etan and Zaba fields in the block. In 2011, Open Economics, the Italy-based economic think tank, projected that Block 245 would cumulatively increase Nigeria's GDP by $41 billion and generate $3.9 billion in tax revenues to the Federation over the 25-year lifespan of the project. In 2018, Resources for Development Consulting, a Canadian think tank, projected revenues of between $9.8 billion and $15.6 billion to the Federation under different scenarios over the project lifespan. The block would add at least 150,000 barrels per day to Nigeria's output when production starts fully. Therefore, by every measure, Block 245 is not a little asset.
You see, when President Obasanjo came to power in May 1999, he revoked many OPLs awarded by General Abacha, but he did not touch OPL 245 and OPL 246. Well, the same month, Chief Dan Etete, former Minister of Petroleum Resources, came out as a consultant and a public face of Malabu, the allottee of Block 245. And Malabu made a down payment of $2.04 million out of a $20 million signature bonus, and this left a balance of $17.96 million. On March 9, 2001, Mr. Macaulay Ofure, the director of the Department of Petroleum Resources, then DPR, but now NUPRC, the oil industry regulator, wrote to Malabu, giving the company the go-ahead to develop the block. Thereafter, Malabu approached Shell Nigeria Exploration and Production Company Limited (SNEPCO), which is a subsidiary of Royal Dutch Shell, to propose a joint development under what is called farm-in agreement. Now, under a farm-in agreement, SNEPCO, as a technical partner, was to take 40% stake in the block, while Malabu will retain 60%. So SNEPCO was to pay $17.96 million. You remember the balance of the signature bonus, and bear the costs of exploration and development. But that's not all. It was also to bear the costs of Malabu's obligations. It would amount essentially to SNEPCO giving a loan to Malabu to pay for its own share of the costs. Well, Malabu will then repay the loan from its share of oil production. But then SNEPCO initially was reluctant to take up the offer, but then it said it did after receiving some written representations from Malabu's registered shareholders that they, get this, were the only two shareholders, and that Etete and Mr. Mohammed Abacha had no interest in Malabu. SNEPCO also said it obtained assurance from the Nigerian government that it had no intention to revoke the block from Malabu. Now, on March 29, 2001, SNEPCO assigned its rights and obligations under the farming agreement to Shell Nigeria Ultra Deep Limited, which is its sister company, with the consent of Malabu, of course. Now, March 30, 2001, Malabu and Shell Ultra Deep executed the agreement, but Shell Ultra Deep took the 40% stake and became the operator of the block under a JOA, that's a Joint Operation Agreement. Fast forward to April 6, 2001, where Shell Ultra Deep issued a check of $17.96 billion to the federal government for the balance of a signature bonus, although it was not cashed, as Nigeria presented a check at Citibank, New York, instead of Citibank, Nigeria. Well, I need to grab a seat for this one. You see, with the regulatory approval of the Joint Operation Agreement, the Ministry of Petroleum Resources issued Malabu with the Oil Prospecting License number 245. It was dated May 15, 2001 and effective from April 29, 1998, which is the original date of award. The title deed was then forwarded to Malabu via a letter dated May 24, 2001. And all was well, or so everyone thought. Suddenly, on July 2, 2001, the Obasanjo administration announced the revocation of OPL 245 from Malabu. Now that was a major twist in the tale. In its letter to Malabu, the DPR simply said the allocation had been withdrawn and the title deed revoked. Etete would later allege that Obasanjo wanted to take over the block and that his resistance led to the summary revocation. Obasanjo denied. and threatened to sue him for defamation, but did not follow through. In April 2001, Shell, Ultradeep, and ExxonMobil were invited by the federal government to compete for the block as production contractors to the NNPC, which owned the block. So Shell Ultradeep, which was Malabu's technical partner before the revocation, was thereafter awarded OPL 245 by the federal government in May 2002. Shell Ultradeep was asked to pay a new signature bonus of $210 million since it was no longer a concession under that indigenous exploration program. Yes. When Shell Ultradeep was awarded OPL 245 in May 2002, it commenced International Chamber of Commerce arbitration proceedings against Malabu, apparently to protect itself over the new state of affairs. So in August 2002, Malabu also commenced proceedings in a New York federal court against the Nigerian government, SNEPCO, Shell Ultradeep, and other Shell entities. So Malabu also petitioned the Nigerian House of Representatives over the revocation. And in May 2003, the House of Representatives issued its findings in favor of Malabu, concluding that OPL 245 was legally awarded to Malabu and that the revocation should be set aside. But that's not all. Also, it recommended that Shell Ultradeep pay $550 million compensation to Malabu. Well, President Obasanjo did not act on that report, and in September 2003, Malabu filed a case in a Nigerian court against the federal government, NNPC, and Shell Ultradeep, seeking a reinstatement of OPL 245 and an award of $100 million in damages. But fast forward to November 2004, the International Chamber of Commerce panel ruled in favor of Shell, describing as lawful the actions of the Nigerian government in revoking that license. But the ICC also declared that Shell was not to blame for the revocation, and the company was right to participate in the bidding process after that revocation. Well, in December 2003, Shell Ultradeep paid $1 million of a signature bonus and deposited the balance of $209 million in an escrow account at the JP Morgan Bank in London because of the dispute, of course. Well, the escrow account was operated jointly by the oil company and the federal government of Nigeria, and that's pending the resolution of all the disputes. Well, NNPC then entered into a production sharing contract, a PSC, with Shell Ultradeep for the development of OPL 245. And while all legal tussles were going on, Shell Ultradeep began oil prospecting. And on March the 16th, 2006, Malabu's case at the Federal High Court was struck out based on the Public Officers Protection Act. But the court ruled that Malabu filed its action out of time. But Malabu was dissatisfied and it lodged an appeal. You see, while Malabu's appeal was pending in court, something interesting happened. Take a look at this. The federal government's lawyers, Babalaki and Co., wrote to Mr. Bayojo, the Attorney General of the Federation, to raise a point of law, warning that the federal government might lose a case and it will be costly. Well, on receipt of the letter, Ojo wrote to Dr. Edmond Dalcoru, who was a Minister of State for Petroleum Resources, asking for an out-of-court settlement, of course based on Babalaki and Co.'s advice. And on October the 3rd, 2006, Dalcoru wrote to President Obasanjo to inform him of the proposed out-of-court settlement and to seek his approval to proceed with it.
Docu wrote, "In the light of the above, Mr. President is respectfully invited to approve the proposal for out-of-court settlement of the suit brought by Malabu in respect of OPL 245 as outlined."
And President Obasanjo wrote, "Minister of State, approved." On November the 30th, 2006, the settlement agreement was signed by the federal government and Malabu. It was then registered as a consent judgment of the Federal High Court. The terms of the settlement agreement were that the federal government would reallocate Block 245 to Malabu in the spirit of amicable settlement and without any admission of liability for any alleged wrongful, unlawful, unjust, or any like conduct. That the new signature bonus shall be $210 million. But But since Malabu had earlier paid $2,040,000, the balance will be $207,960,000 payable within 12 months after the execution of the agreement that Malabu could assign Block 245 or any part of it in accordance with the provisions of the Petroleum Act, that Malabu shall not raise any issues or bring any court action again regarding losses, liabilities or damages over the revocation of Block 245, that Malabu shall terminate its case at the Court of Appeal after the execution of the settlement agreement. On December 2, 2006, Docu wrote to Etete to confirm that the settlement agreement had been approved by Obasanjo. Docu also informed Shell Ultra Deep that as part of the settlement, the oil company will be awarded another block with comparable potential and hydrocarbon prospectivity. Now, following this, Malabu discontinued its case at the Court of Appeal on January 16, 2007. But that's not all. You see, years later, then President Obasanjo would deny approving that agreement. And the settlement agreement was just another lap in the long-distance race. Shell Ultra Deep was predictably injured, but at the turn of events, it had a good claim on the federal government because it had been assured that all was well before it went ahead to de-risk its investment in the block. And now, OPL 245 was gone again. Its next step? Shell said it held a meeting with Obasanjo in February 2007, where it was agreed that Malabu should be given a share of NNPC's 60% stake in the block. Malabu rejected the offer, insisting on the implementation of the settlement agreement. In April 2007, Shell Ultra Deep filed a notice of arbitration against Nigeria at the International Center for the Settlement of Investment Disputes, an organ of the World Bank. It demanded a compensation of $1.8 billion, alleging expropriation of its estimated investment of $500 million. In his last days in office, Obasanjo wrote to Docu, seeking to clarify his position. He said Shell Ultra Deep should remain the contractor, having de-risked the block, while Malabu and NNPC will be the concessionaires as co-owners. And when President Umar Musa Yar'Adua, when he assumed office in May 2007, the OPL 245 saga was one of the issues he inherited from the Obasanjo administration. So in August 2007, Yar'Adua set up an interministerial committee to resolve the dispute in a way that would accommodate the interests of both Malabu and Shell Ultra Deep. Now, part of the proposal was to compensate Shell with an oil block with equivalent of 50% of Block 245, but Shell rejected the offer. And in comes Dr. Goodluck Jonathan, who became president after the death of Yar'Adua. But it was barely a week in office when on May 11, 2010, Malabu wrote a letter to him asking the new administration to implement the 2006 settlement agreement, which was entered into by the Obasanjo administration. Well, the letter was signed by Mr. Raskik Benige, who's Malabu's company secretary and legal advisor. So what did Jonathan do? Well, he asked Mr. Mohammed Bello Adoke, the Attorney General, for legal opinion on the settlement agreement. And in his response, Adoke said he had reviewed all the relevant documents, and his opinion was that the 2006 agreement was subsisting and enforceable. So Jonathan decided to implement the 2006 settlement agreement. This was communicated to Malabu by Mrs. Dezani Alison Madueke, Minister of Petroleum Resources, via letter dated July 2, 2010, ironically on the 9th anniversary of the Block 245 revocation. Still, this did not resolve the problem, as Malabu and Shell still bore historical grudges against each other. In fact, Shell had an outstanding arbitration award of $20 million against Malabu, and had also launched an arbitration proceedings against the Nigerian government over the 2006 settlement agreement. That should have been the end of the story, right? But no, this story is far from over, because after the return of OPL 245 to Malabu, Malabu engaged the services of middlemen to market the block, indicating that it was ready to sell off its entire interest. Mr. Adnan Agaev, a former Russian intelligence officer, had introduced Mr. Emeka Obi, a Nigerian businessman, to Malabu in December 2009 to help it find buyers. And that's even before the block was returned to the government. Eni, an Italian company, indicated interest in acquiring the block. But Shell was still interested as well, having invested hundreds of millions of dollars in developing the acreage. Malabu was no longer interested in doing business with Shell because of the bitter history between them, and Eni could not go ahead with its interest because of Shell's position. Deadlock. So the parties approached the federal government, asking it to broker a resolution of the crisis of confidence. Shell and Eni offered to acquire Malabu's 100% in Block 245, and after a series of negotiations and meetings by all the parties, a number of resolutions were reached. 1. Malabu and Shell Ultra Deep agreed to terminate all the court and arbitration proceedings regarding OPL 245. 2. Malabu agreed to relinquish its entire interest in OPL 245 for a compensation of $1.092 billion. 3. Federal government agreed to indemnify Shell and Eni against future claims on the oil block. And 4. Shell and Eni agreed to pay the agreed price of $1.092 billion to the Nigerian account at JP Morgan in London, in addition to the $210 million signature bonus. In all, the payments came to $1.3 billion. But let's backtrack a bit. Now recall that in December 2003, Shell Ultra Deep had paid $1 million of the signature bonus and deposited the balance of $209 million in an escrow account at JP Morgan Bank, and that was pending the resolution of the dispute. As disclosed later, contributions from Shell entities amounted to just under $320 million, including the release of the signature bonus from the escrow account. Now, Eni contributed the remainder $980 million. But there's one more detail. Before the Block 245 resolution agreements were signed, Mr. Andrew Obaje, who was the then director of the Department of Petroleum Resources, raised an objection over the non-provision for a back-in right for Nigeria. Now, what is a back-in right? Well, a back-in right would allow the country to take a share in the oil block in the future. A committee was set up to look into Mr. Obaje's objection, and the back-in right provision was inserted. So on April 29, 2011, Malabu, Shell, Eni, and the federal government of Nigeria signed the suite of agreements known as Block 245 Resolution Agreements. So it appeared the whole controversy had finally ended. But another phase started after the execution of the resolution agreements. And so, the federal government instructed JP Morgan to transfer Malabu's $1.1 billion to the account of Petrol Services Company Limited with BML. That's a bank in Lebanon. Now, that was the account provided by Malabu. On May 25, 2011, JP Morgan tried to transfer the money, but the Lebanese bank rejected the transfer. And that was the first red flag. On June 15, 2011, Malabu wrote to the Nigerian Minister of State for Finance, Dr. Yerima Lawan Ngama, to inform him of a development. And Malabu then provided its Nigerian bank accounts, which Ngama then communicated to JP Morgan. But another problem was brewing. In July 2011, it emerged that Malabu was having a running battle with its own partners, who said they were middlemen and consultants in the OPL 245 transaction, and they wanted their payment. Emeka Obi's company, Energy Ventures Partners EVP Limited, had on July 18, 2011 secured an ex parte order from a UK court, freezing $200 million of Malabu's money. He alleged that there was a verbal agreement to pay him that amount as finder's fee. He also asked the court to award $15 million to him as cost. JP Morgan was served that freezing order. A second company, International Legal Consulting Limited, a Swiss entity owned by Agaev, and sued Malabu for $65 million in the US. Agaev, Obi's friend, claimed he was entitled to 6% of the payment to Malabu. Well, the bank got in touch with the Nigerian government over the court order. Officials of the finance ministry referred the letter to Docu, the Attorney General, and asked for his legal advice. In his response dated July 8, 2011, Docu advised the ministry that a court order should be obeyed regarding the sums to be frozen and the unencumbered amount could be transferred to Malabu's nominated account. Well, officials of the Ministry of Finance thereafter instructed JP Morgan to transfer a total of $875 million to Malabu's bank accounts in Nigeria and to withhold the balance pending the outcome of the court proceedings. But JP Morgan also sought and got the approval of the UK Serious Organized Crime Office before transferring $401,540,000 to Malabu's account with First Bank of Nigeria plc and $400 million to its account with Keystone Bank. Well, that happened on August 23, 2011. The balance of $290 million was withheld by JP Morgan, but the court cases eventually went in Malabu's favor. You see, telling the OPL story is definitely taking its toll, hence the need for some room to stretch. Because with the OPL 245, nothing is ever done and dusted. At every turn, there is always a new controversy. And what happens next turned global attention to OPL 245 and led to what anti-corruption campaigners called the world's biggest corporate fraud trial. A coalition of international NGOs had started raising issues after Block 245 resolution agreements were signed in April 2011. They alleged money laundering and international corruption. They were particularly alarmed at the involvement of Etete, especially as he had been convicted of money laundering in France in 2007. It said Malabu was engaged in criminality, reporting that it was registered using a fictitious character and that it maintained a fake address with the Corporate Affairs Commission. And this marks the birth of a Malabu scandal in media reportage. They alleged as follows: that OPL 245 was unlawfully acquired by Etete when he was a Minister of Petroleum Resources, and that his interest in OPL 245 was held through Malabu. That Eni negotiated and participated in a corrupt agreement that enabled Etete to crystallize and launder these illegally obtained assets through a convoluted deal that resulted in a consortium of Eni and Shell acquiring OPL 245 through the Resolution Agreement of April 2011. That the belief that both Etete and the son of General Abacha were shareholders when the oil block was awarded raised the concern that the award of OPL 245 was a way for Nigeria's ruling elites to profit illicitly from the country's natural resources. There's a long list. The next one is that after the death of Abacha, Etete reportedly increased his shareholding in Malabu fraudulently, taking control of 100% of the company, and that Mohamed Abacha had petitioned the EFCC to investigate the matter in January 2012. Well, the Corner House and Global Witness also petitioned the Metropolitan Police Service in London to look into the OPL 245 transaction. The international NGO's partners in Nigeria were Header Resource Center and Premium Times. So in September 2013, Recommon, the Corner House, and Global Witness made a significant headway when they sent a similar petition to the Public Prosecutor's Office in Milan, Italy. Don't forget that Eni is an Italian company. So on December 20th, 2017, the Court of Milan issued a decree ordering the indictment of 15 individuals and entities, including Shell, Eni, Etete, and some former employees of the oil companies. They were ordered to appear before the 10th Division of the Court of Milan at the commencement of hearing, scheduled for March 5th, 2018. When Nigeria joined the lawsuit as the injured civil party, the prosecutors filed separate charges against Mr. Emeka Obi, the CEO of Energy Venture Partners, and Alhaji Aliyu Abubakar, who's a Nigerian property developer accused of being the conduit through which bribes were shared to government officials. The same month, Nigeria filed a civil suit against JP Morgan in a UK court seeking a $1.7 billion compensation from the bank for transferring $875 million to Malabu in 2011. Now see what happened. Nigeria invoked the Queen's Care Duty Doctrine, arguing that JP Morgan should have known that the money transferred to Malabu was part of a fraudulent scheme. But in Nigeria, the EFCC filed court cases against Docu, Aliyu, Binige, Malabu, Ajib, same as Eni, Shell Nigeria Exploration, and Shell Ultra Deep, a long list, alleging corruption, money laundering, and conspiracy to commit forgery. So, Malabu scandal started to feature prominently in the Nigerian media coverage of the court proceedings. You see, it's not uncommon for Nigerian government officials and their relatives to enjoy state patronage. However, it is often kept discreet and managed by fronts, at least until the beneficial owners are out of office. In the case of OPL 245, there were many unusual developments. Etete, as the Minister of Petroleum Resources, awarded OPL 245 to Malabu in April 1998. Well, General Abacha was the military head of state. And when Abacha died suddenly on June the 8th, 1998, the Nigerian political landscape changed dramatically. The Abachas lost power, and Etete became a former minister. As was later confirmed during court proceedings, Malabu had registered with disguised identities. In the original corporate registration documents, the shareholders were listed as follows: Mohammed Sani, 50%, Kweku Amafara, 30%, Wabi Hassan, 20%. Well, Mohammed Sani was in fact Mohammed Abacha. Kweku Amafara was, from all indications, Dan Etete. Wabi Hassan was a stand-in for Alhaji Adamu Hassan, then Nigeria's ambassador to the United States. In November 1998, Raski Binige, Malabu's company secretary, issued a power of attorney to Etete, naming him as the company's consultant and empowering him to act on behalf of the company in all matters. Instructively, Binige wrote inter alia that Etete was authorized to transact, manage, carry on and do all and every business matter and things requisite and necessary, or in any manner connected with or having reference to the business and affairs of a company, and for such purposes to conduct all correspondence appertaining to such businesses and affairs. Well, this total surrender, so to say, sounded curious. It must be noted that Mohammed Abacha was detained in 1999 over the 1996 murder of Kudirat Abiola, wife of the late Bashir MKO Abiola, the winner of the annulled June 12, 1993 presidential election. Well, Abacha was released from detention in 2002, by which time OPL 245 had been revoked and Etete had become the public face of Malabu as he started fighting for the license to be restored. Well, Etete himself denied owning Malabu, telling this day newspaper in an interview on August 31, 2002 that he did not buy anything in Malabu. In fact, he described himself as Malabu's consultant. But contrary to initial claims by Shell officials that he did not know Etete had an interest in Malabu, emails obtained by Global Witness and Finance uncovered in 2017 appeared to show that the companies dealt directly with Etete for at least a year before the OPL 245 deal was finalized in April 2011. Mohammed Abacha alleged in court that Malabu's registration documents were altered without a board meeting, and his name was removed as a shareholder.
Malabu Oil and Gas was incorporated in 1998 to seek allocation of oil prospecting license with the Petroleum Ministry. OPL 214 and OPL 245 were subsequently granted to Malabu. At the time of granting the licenses, the shareholders were Mohammed Sani with 10 million shares, Kweku Amafega 6 million shares, and Wabi Hassan with 4 million shares. Kweku Amafega was a pseudonym of Chief Dan Etete, and Wabi Hassan was a pseudonym of Hassan Adamu. After the death of my father in June 1998, I was handed some documents and I was made aware of alterations and changes in Malabu. Subsequently, I gave a power of attorney to the late AVM Mukhtar Mohammed to kindly oversee the affairs of Malabu. He traveled to London to see Chief Dan Etete, who had fled the country then. It became impossible for him to see Etete. Subsequently, I sought the help of my lawyer, Abubakar Malami, who later became Attorney General of the Federation under President Buhari, to go to CAC and conduct a search. After some time, with no luck and response, I got Aro Atabo to conduct a search at CAC, and it was discovered that several alterations had already been done in June 1998 and November 1998, where my name was totally removed, and other changes in 2000, where shares which were altered and converted, and my name no longer appeared.
In 2011, when Malabu was negotiating to sell off its interest in OPL 245 to Shell and Eni, Abacha said that he made every effort to warn the multinational oil companies regarding the outstanding shareholders' dispute.
First step was to file a suit at Federal High Court, Abuja, seeking the courts to assert my ownership of the 10 million shares in Malabu. Then, I asked my lawyers in London to write Shell and Eni Agip, cautioning them against entering any agreement with Malabu, and I intimated them of being a director and a shareholder. It was a caveat to Shell and Agip. I got Aro Atabo to write a letter to the Netherlands and Italian embassy, the home embassies of Shell and Agip, to pass the information that the oil companies should not participate in any relationship with Malabu. Finally, I asked Atabo to publish in 2 newspapers, cautioning anyone and forbidding anyone from entering into any negotiations, event, or partnership with Malabu. Unfortunately, all fell on deaf ears.
Remarkably, Abacha told the courts that he did not pay for his shares in Malabu, which in itself could undermine his claim to ownership. Well, after Shell and Eni acquired OPL 245 and Malabu was paid off, Abacha's lawyers wrote to Docu asking him to help resolve the shareholders' dispute so that Abacha could get his share. Well, the letter was dated January the 20th, 2012, and Adoke, in his response, said Malabu was a private company on whose behalf the Attorney General of the Federation could not act. He advised that the directors should hold a meeting to resolve the issue, otherwise they should approach a court of law for judicial intervention. So on December the 18th, 2012, Abacha wrote to Adoke to inform him that he had nominated 2 lawyers to represent him at the dispute resolution meetings with other Malabu shareholders. But the Nigerian House of Representatives is also said to have looked into the dispute, reportedly at the instance of Abacha, but nothing came out of its report that the Block 245 resolution agreement be nullified. Well, Abacha clearly felt shortchanged, although many may raise moral issues as to how his father, as a head of state, would allocate an oil block to a company which he had interest. The same moral question would apply to Etete, who as a Minister of Petroleum Resources allocated the block to Malabu. But there was an issue of conflict of interest on both sides and a potential violation of a code of conduct law. But surprisingly, Obasanjo did not question the legality of Etete's ownership of Malabu while revoking the block in 2002. Also, Obasanjo did not raise any issue of a possible violation of a code of conduct law while agreeing to return the block through the 2006 settlement agreement. Well, with the settlement agreement, subsequent administrations recognized Etete as the owner of Malabu and dealt with him in that capacity. So while Malabu was enmeshed in controversies all over the world, General Danjuma was doing well with his OPL 246. Sapetro, his company, entered into technical partnership with Total and Brass Oil to develop Block 246. Immediately, it secured the prospecting license in 1998. Well, in April 2000, the companies discovered oil in 5 fields. And in 2005, The OPL was converted to an oil mining license, OML 130, and in June 2006, the China National Offshore Oil Corporation acquired 45% of OPL 246 for $1.7 billion. Danjuma became one of the richest Nigerians and went on to establish his status as a philanthropist. Before President Muhammadu Buhari came to office in May 2015, the Malabu scandal had been mostly centered on the actions of the executives of Shell and Eni, as well as Etete. Adoke, who was the Attorney General of the Federation under Goodluck Jonathan, was mentioned mostly in passing. However, as soon as Buhari became president, the narrative changed dramatically and Adoke became the central figure. In fact, at a stage, the Nigerian government built its entire OPL 245 case on the allegation that Adoke corruptly enriched himself. Oddly, the OPL 245 transaction involved more than a dozen government officials under Presidents Obasanjo and Jonathan. In fact, the 2006 agreement was authorized by President Obasanjo and signed by Dr. Edmund Dalkoro, his Minister of State for Petroleum, and Chief Bayojo, his Attorney General of the Federation. The Block 245 resolution agreements were authorized by President Jonathan and signed by Adoke as Attorney General, Mrs. Dezani Madueke as the Minister of Petroleum Resources, and Mr. Olusegun Aganga as Minister of Finance. Well, the Category A signatories to the JP Morgan account from where transfers were made to Malabu were Dr. Yerima Lawan Ngama, who was the Minister of State for Finance, and Mr. Danladi Kifasi, the Permanent Secretary of the Federal Ministry of Finance. The Category B signatories were Mr. Otunla Jonah Oguneyi, then Accountant General of the Federation, and Alhaji Babayo Shehu, who was then Director of Funds in the Office of the Accountant General of the Federation. But Adoke was the only former government official charged to court by the Buhari administration. Now, Nigeria's lawyers tried to build a case of corruption around Adoke, so his name was mentioned prominently in the court cases in Italy and the UK. So how did Adoke become the poster boy? Well, till date, only Adoke has extensively told his own side of the OPL 245 story. In 2019, he published a book, Burden of Service, chronicling his time in office as the Attorney General. And in that book, Adoke stopped short of saying Buhari sent the EFCC after him to sort of exact revenge for Mohamed Abacha for reasons best known to him. I recall that Abacha had sought Adoke's intervention in Malabu shareholders' dispute after payments were made for Block 245 by Shell and Eni. Well, Adoke said he turned him down because it was outside the scope of the functions of the Attorney General of the Federation. Adoke wrote,
President Buhari was misled into thinking that I was not fair to the Abacha family in the Malabu transaction. That Mohamed Abacha suddenly began to grow in confidence under the Buhari government is not in doubt.
Incidentally, Abacha was the EFCC's star witness in the criminal trial of Adoke and others at the FCT High Court Abuja. In fact, Abacha attended court hearings throughout. Although it should be noted that neither he nor the other EFCC witnesses accused Adoke of committing the forgery of Malabu's documents, but really was the EFCC fighting for Abacha. In October 2022, Mr. Abdurrashid Bawa, the then EFCC chairman, wrote to the Attorney General, Mr. Abubakar Malami, asking that Eni should set aside $500 million to compensate Mohamed Abacha if the case against Adoke and the oil companies were to be discontinued. Now, when President Bola Tinubu assumed office and removed Bawa, he appointed Mr. Abdulkarim Chukul as the acting chairman. Weeks after assuming office, Mr. Chukul also wrote to Tinubu in a letter dated August 25, 2023, asking that the federal government should enter into negotiations with Shell and Eni to compensate Abacha and Pecos Energy, whom he described as the real owners of Malabu. While AFCC's sustained advocacy for Abacha tends to lend credence to Adoke's allegations against the commission. Adoke was on self-exile in Ghana for most of Buhari's first term in office between 2015 and 2019, the EFCC conducted a number of raids on his houses in Kano and Kogi State, but reportedly did not find anything incriminating. In fact, in April 2019, the EFCC secured a warrant of arrest against him. Although the warrant of arrest was set aside by the court in October 2019, Nigeria did not withdraw the red notice it had sent to Interpol. Now fast forward to November the 12th, 2019, Adoke was arrested by Interpol in Dubai, the United Arab Emirates, and detained for 35 days. On his return to Nigeria, he was arrested and detained for 55 days by the EFCC, during which he was charged to 2 different courts. But the major allegation filed against Adoke by the EFCC was that he collected a gratification of 300 million naira for his role in the Block 245 resolution agreement. He was said to have collected the gratification in 2013, 2 years after the agreements were signed. Well, the EFCC alleged that Alhaji Abubakar Aliyu, the property developer who was accused of distributing bribes in the OPL 245 deals, paid bribes into Adoke's account at Unity Bank. In the burden of service, Adoke denied receiving any bribe from the OPL 245 transaction, maintaining that the particulars of the loan he took from Unity Bank PLC in 2012 to buy property from Aliyu were manipulated by the EFCC to create the impression that it was gratification. Adoke said he had been approached in 2012 by Aliyu with regards to an Abuja property valued at 500 million naira. But he said he got a loan of 300 million naira from Unity Bank, while his equity contribution was to be 200 million naira. The loan was approved and transferred to Carlin International, which is Aliyu's company. However, when Adoke failed to pay up his 200 million naira equity, which he blamed on his inability to find a buyer for the land he wanted to sell to raise the money, Aliyu refunded the 300 million naira to Unity Bank in 2013 and retrieved the title deeds. Aliyu then sold the property located at plot 3271 Cadastral Zone AO6, Maitama District, Abuja, to the CBN. Till date, the CBN owns that property. The EFCC argument was that the money refunded to the bank in 2013 by Aliyu was a bribe in disguise. Before and during Adoke's criminal trial, several developments had appeared to weaken the EFCC's cases against him. In a letter dated September the 15th, 2017, Mr. Abubakar Malami, the Attorney General of the Federation, wrote to President Buhari on the court case, arguing thus:
The EFCC investigation and attached proof of evidence do not appear to have clearly revealed the case of fraud against the parties who claim to have acted in their official capacities with the approval of 3 consecutive presidents of the federal government of Nigeria, at the time with further claim that the matter was intended to be resolved in national interest, thereby saving the nation acrimonious litigations resulting in high legal fees and the dormancy of the oil field while litigation lasted.
Malami also wrote to Mr. Ibrahim Magu, the EFCC acting chairman, on September the 20th, 2017 to state the legal basis on which the proposed criminal charge over OPL 245 should be dropped. On December the 13th, 2017, Dr. Ibe Kachiku, as a Minister of State for Petroleum Resources, also wrote to Buhari through the Chief of Staff, Malam Abba Kyari, asking the federal government to abide by the 2006 settlement agreement. And on February the 6th, 2023, Malami wrote to Buhari again, admitting that Nigeria could not win the court cases on OPL 245 and asking that the proceedings be terminated so that the oil block could start production in the interest of the Nigerian economy. Now, regarding the court proceedings referred to by Malami, things did not go well for Nigeria in the decided cases, and things were not looking too good for the ongoing cases. In the court of Milan, one of the defendants, Mr. Vincenzo Armana, a former Eni manager, testified on July the 17th, 2019 that Adoke threatened to arrest and jail officials discussing kickbacks during the transaction with Malabu in 2011. In Nigeria, a major setback in the EFCC case emerged during the trials. The prosecution witnesses did not make incriminating statements against Adoke. Some did not even mention Adoke's name at all. In the case before Justice Abubakar Idris Kutigi of the FCT High Court, Mr. Ibrahim Ahmed, who was the EFCC prosecution witness, said the 300 million naira deposited into Adoke's Unity Bank's account was a bribe from Aliyu. But in the money laundering case before Justice Inyangeko of the Federal High Court, the same EFCC prosecution witness said that the 300 million naira was the repayment of the loan which Adoke took from the bank. Ahmed also confirmed that Adoke did not take possession of the property and that it was sold to the CBN. Aliyu, meanwhile, had told Justice Eko that the EFCC asked him to lie that he gave Adoke a bribe of $20 million. This, Aliyu said, was for him to regain his freedom from detention and be used as a prosecution witness instead. He alleged intimidation by the EFCC team led by Mr. Balasanga to make him implicate Adoke and Jonathan. Mr. Rislanuddin Mohammed was a former acting Unity Bank MD who stood as the EFCC key witness, also told Justice Eko that the 300 million naira was a loan the bank gave to Adoke and that there was no money laundering involved in the cash repayment. Clearly, the entire Malabu saga turned out to be a monumental waste of time and resources for everyone concerned. Nigerian anti-corruption campaigners suffered a litany of setbacks and losses in their attempts to prove that there was a fraud. Every single court of law determined that there was no evidence that fraud was committed in the Block 245 resolution agreement. The losses started in the US, where the Department of Justice and Securities and Exchange Commission investigated the petitions by Recommon, the Corner House, and the Global Witness, and closed the inquiries without bringing any charges against Shell, Eni, and others. And on May the 22nd, 2020, a UK commercial court declined jurisdiction in a case Nigeria filed against Shell and Eni. But the biggest blow was the criminal trial at the Court of Milan, Italy, which had drawn global attention. But it was tagged by the NGOs as the world's biggest corporate corruption trial. But after 3 years of trial and 74 hearings, the Court of Milan discharged and acquitted Shell, Eni, Tete, and other defendants of the corruption charge on March the 17th, 2021. The Honorable Justice Marco Tremolada, the presiding judge who read the judgment, declared thus:
This court acquits the 15 defendants of the criminal charges brought against them and reported in the court of indictment because it has not been proven that an offense was committed, and consequently dismisses all of the demands proposed regarding criminal matters.
On July the 17th, 2022, Celestina Gravina, the Italian Attorney General, terminated the appeal in the trial of Shell and others. It essentially said that the case has no basis. In fact, it should have finished earlier. So fast-tracked to June the 14th, 2022, Nigeria also lost the $1.7 billion Queen's Care claim which it filed against JP Morgan Bank over the transfer of Block 245 sale proceeds to Malabu.
Was I satisfied that 1. Mr. Adoke caused the payment instructions, and 2. Mr. Adoke was receiving monies by way of bribe? I should certainly have concluded that it was a fair inference that he had caused the payment instructions in pursuance of such an agreement. However, since I have concluded that he did not cause the payment instructions, and that on the balance of probabilities he was not bribed, the point is purely contingent.
There were several court proceedings in Nigeria as well. In 2020, the EFCC charged Adoke, Aliyu, Benige, Malabu, Ajib, Shell Ultra Deep, and Shell Nigeria Exploration before the FCT High Court. The FCC alleged money laundering, violation of public policy, and illegal alteration of Malabu's company registration document. But in another blow, the FCT High Court on March 28, 2023, upheld the no-case submission of the defendants and dismissed the charge. In fact, Justice Abubakar Idris Kutigi declared, mere allegations, no matter how weighty, do not translate to or are tantamount to fact and evidence. And finally, on April the 19th, 2024, Justice Eko of the Federal High Court delivered his ruling in the separate case of money laundering against Docu and Aliyu. Although there was no mention of OPL 245 or Malabu in this case, it was the same particulars before Justice Kutigi that the EFCC charged before Justice Eko, and in upholding Adoke's no-case submission as well as discharging and acquitting the former minister, Justice Eko, however, rules that Aliyu had a case to answer in the other counts filed against him in which Docu was not mentioned. Notably, the EFCC did not appeal the rulings of the FCC High Court and the Federal High Court that discharged and acquitted Docu. Well, the OPL 245 story never really comes to an end, does it? Because on October the 8th, 2024, an Italian court jailed the prosecutors for hiding vital evidence during the trial of Shell and 14 other defendants by the Court of Milan. Fabio De Pascal and Sergio Spadaro, who are the two prosecutors, were sentenced to 8 months in prison by Brescia Court for not disclosing documents that could have vindicated the defendants. Docu, though not on trial in Italy, had earlier written to complain to the Court of Milan that the prosecutors were hiding evidence that showed that the Abuja property linked to him, which was described as a bribe from the OPL 245 deal, actually belongs to the Central Bank of Nigeria. Docu also complained to the Nigerian police that an email was forged and an interview with an imposter was stage-managed to implicate him in the court cases. Well, the police investigated and charged Mr. Olariwaju Suraju, the frontline Nigerian anti-corruption campaigner and chairman of Header Resource Center, to court for allegedly circulating the materials on social media. Header was, by the way, the Nigerian partner of the international NGOs that brought the Malabu case to global attention. You remember? Well, the court cases against Suraju was eventually terminated by the government before the trial could start. For now, can we conclude that the long-running OPL 245 soap opera, which started unnoticed in 1998 and went on to acquire global fame, has ended? With all the major court cases concluded and the Italian prosecutors jailed, and with the Nigerian government given the go-ahead to develop the oil block, can we finally say we have seen the last episode of the OPL saga? Well, don't bet on it, because with OPL 245, it is never fully over.